Good afternoon. I'm Kathleen Chow, Program Manager of the Walnut Creek Library Foundation, and I'd like to welcome you to our virtual Finance 101 program, Trust and Estate Planning, What You Really Need to Know with R. Gordon Baker, Jr. I'd like to take a moment to thank our media and print sponsors, East Bay Times and Minuteman Press Lafayette. Gordon Baker is certified as a specialist in estate planning, trust, and probate law. He has over 30 years of experience and is an accredited estate planner. Effective estate plan allows your wishes to be carried out while minimizing costs and conflicts. Today, Gordon will explain the estate planning process for arranging the transfer of your property and providing for your care should you need it in an efficient manner. A copy of the outline for today's presentation can be downloaded from the chat box if you wish to follow along with Gordon. If you enjoyed tonight's program, please consider making a donation to the Library Foundation to support their programs. Visit our website, www.wclibrary.org, to donate or click on the link located in the chat box. Following our presentation, we will have a brief Q&A. You can submit your questions for Gordon in the Q&A box at any time throughout his presentation. And now, without further ado, please join me in welcoming Gordon Baker.
Well, hello. Hopefully I put the right buttons and people can actually hear and see me. Thank you very much for showing up for this. This is kind of a new thing for me, doing it purely by Zoom. Normally I have audiences, which are kind of fun because, you know, you get questions and things like that. But let's get into it. Estate planning, one of the most fun things in the world that a person can do. What is it? Well, it's really just a process. Most people, when they think of estate planning, what they're thinking about is what happens to my stuff when I die, and which is not as much fun as some of the other aspects of it. While that is a major portion, perhaps even the one that's most relevant to most people, it isn't the whole ball of wax. To the contrary, the estate planning is basically the process of arranging for not only what happens in the event that you die, but in many cases, more important, to arrange for the management of your assets and for the provision for healthcare plans for you in the event that you become incapacitated. And over the course of my practice, it's been interesting to see that that has become an increasingly important part of the estate planning process. So what estate planning does, it allows you to determine how your property is going to be managed during your lifetime if you become unable, or as in my dad's case, just unwilling to manage things for himself. You can decide who will make healthcare decisions for you if you can't make them for yourself. We'll touch on that later through what's called an advanced healthcare directive. You can appoint someone to make decisions regarding your property if you are unable to do so. That's done through a power of attorney, a durable power of attorney, which we'll discuss a little bit later. A really important thing to be addressed for younger people, and in fact, I just had this conversation with my daughter who just had one of my grandchildren a few months ago, is who is going to have custody of minor children in the event that the parent is deceased or incapacitated. And for young people, that's in many cases the most important thing they need to consider, even more important than some of the provisions regarding the disposition of the estate. Other things that clients will often ask me about is the disposition of their remains when they're gone. Do they want to be cremated? Do they want to be buried without cremation? Do they want to be buried in a particular place? Those are things that can be handled through the estate planning process. And the key also in estate planning is that if it's done effectively, it can minimize the expense of the entire process, and equally or sometimes more importantly, minimize or mitigate family squabbles regarding those things. Anyway, getting into it, one of the first concerns that almost every client raises with me is estate tax. People will come in, and the first thing is they'll say is, "Gee, Gordon, the most important thing is I don't want to pay any estate tax." Well, the good news, at least through 2026, 25, is that for California residents, in fact, for most Americans, estate tax really isn't a concern. And if you're interested in some of the details of that, download the outline. It goes into it a bit more. But currently, the estate tax and estate and gift tax credit exemption amount, which is basically the amount that you can pass to someone without paying a gift tax or an estate tax, is $12,060,000 per person. Very few of us have in excess of $12,060,000. I wish I did, but that's the way it goes. That amount is indexed for inflation, so next year it's going to go up a good bit, maybe by 8 or 9%, depending on what happens on the inflation numbers the next couple of months. Also, the gift tax credit, which was $15,000 per year. That's the amount, pardon me, the exclusion amount, the amount that a person can give by a gift while you are alive to another person, which was $15,000 for quite a long period of time. Due to inflation, was increased this year to $16,000 per person. And that's great because you do that, you don't even have to file a gift tax return. So most people don't have that amount of money that they're going to have to worry about estate taxes. It's made even better by the fact that in the 2010 Tax Act, we introduced a concept called portability. Portability basically says that if a married person dies and does not use all of their estate tax credit amount, that the surviving spouse can make an election to glom on to that unused estate tax amount and use it themselves. And that's done by filing an estate tax return. What that does is that allows a married couple to pass on currently up to $24,120,000 to anyone that they want without paying any estate tax. So again, very few people have that problem. California is particularly blessed in that while we're considered a high tax state in a lot of ways, California does not have an estate or an inheritance tax. And that's important. One caveat I often raise with people is that if they have particularly real property in other states, particularly New York, Connecticut, most of the New England states, even the state of Washington, many of those other states have estate taxes, and they kick in at rates which are significantly lower than the U.S. estate tax credit. So that's something that if you have property in other states, you might want to be aware of. I've actually had clients who, in anticipation of death, particularly clients from New York, have gotten rid of their New York real estate by doing tax-free exchanges into real estate in other states, just to make sure that it's not going to be subject to state inheritance tax. a side note, but it's important in many cases, is one of the things we've been doing a lot of in recent years is going back and undoing a lot of trusts that were put together, estate plans were put together before 2011, to eliminate what's called a bypass trust. By way of background, before the 2010 Act and this concept of portability came in, the estate tax credit was personal to each human being. And if you didn't use that credit, it went away. It couldn't be used in past. So, and also before then, the amount that could be passed to someone other than a charity or a spouse without paying an estate tax was much lower. I think in 2010, it was $3 million. Before that, not too soon before that, it was only $620,000, $25,000. So a lot of trusts and a lot of wills that were put together before then, and oddly enough, I still seen some that have done since then by people who didn't know what they're doing, have provided that when a spouse dies, that their property would go into a separate trust, usually called a bypass trust or a credit shelter trust, or a B trust, that was set up in such a way that it would benefit the surviving spouse, but would not be considered owned by the surviving spouse, which would mean that it would then not be included in the survivor's estate when that person died. And that was good because that would allow you to use both spouses' full estate tax credit. That's pretty much obsolete, but a lot of people still have them. In fact, I've made a lot of money in recent years on undoing them. The reason that it's not a good idea to have that is that a bypass trust, any irrevocable trust, has some very serious income tax deficiencies. And basically a irrevocable trust, like a bypass trust, is taxed on its taxable income, which isn't distributed, at a rate of 37% federal, when that income that isn't distributed exceeds, I think, $13,400. Plus, it's subject to an 8.4% tax on investment income. So holding income in an irrevocable trust can be extremely disadvantageous. Also, assets in a bypass or irrevocable trust do not get a step up in basis or a basis adjustment when the surviving spouse has died. So that's actually much more exciting than it sounds. It's stressed in the outline. The bottom line, though, is just if you have a will or a trust or plan that was put together before 2011, you should really review it to make sure that it doesn't require the establishment of a bypass trust, because a lot of people have the estate plans that were done 20, 30 years ago. And while they were absolutely superb at the time they were done, they really could be a big problem now. So outside of that, probably don't have any estate tax problems. If you do have estate tax issues, there's a lot you can do to mitigate that, but that is beyond the scope of this program. So we're not going to go into it, even though that's some of the most fun stuff in the world. Now, after I explain to people that they probably don't have an estate tax problem, the next thing I hear is, well, why do I need an estate plan? Which is an excellent question. And it depends, the answer depends upon the situation of the individual. If you have a small estate, a lot, I've had people who at the first death, married couple don't need a whole lot of anything. If all they're worried about is death. But everyone should have something. So why, if you have a small estate, would you want to have some estate planning done? At that point, you'd really want to focus in on a durable power of attorney, which allows someone to handle your financial affairs for you if you become incapacitated, an advanced healthcare directive, which allows someone to make medical decisions for you if you're not able to make them for you, also to determine where you're going to live and things like that if you can't make those decisions. So it's incapacity planning. So with those things, you can avoid the necessity of a conservatorship, which we'll talk a little bit more. You can also designate guardians for minors. Again, as I noted before, really a crucial and often overlooked issue for people who have kids who are under 18. And most importantly, you can make sure that your property goes to the people that you want it to go to in a manner that is appropriate and consistent with your own wishes. Another reason to have an effective plan trust is to avoid the necessity of probate, which we'll talk about in a second, at your death. Now, a larger estate, all of those reasons apply, but also you get into a really large estate with avoidance of estate tax or mitigation of estate tax. And there's usually a lot of things that you can do there. Also, with an effective plan, you can sometimes result in property tax savings if you're passing real property down to children. That's been limited by Prop 19, but it's still there. Also, you can deal with multi-generational planning. A lot of people with larger estates, particularly if you have children who have varying levels of financial success, will look to planning for grandchildren or great-grandchildren, whatever. So instead of giving everything to children, maybe give some children, some grandchildren. Also, you can through that type of planning result in further tax savings, both on estate tax and the special tax on multi-generational gifts. That again is kind of beyond the scope of this, but way fun. The other thing that you can deal with is important is creditor planning. Sometimes you want to benefit a child or someone who, for whatever reason, is not able to effectively manage their own property, either because of special needs, which is going to be discussed at great length by Kirsten Howe next week. That should be a really good presentation. But sometimes people are just spendthrifts and otherwise not able to effectively manage their property. You can't resist temptation, can't resist being unduly influenced by others, their soft touches. And with an effective estate plan, you can provide that gifts to those people would be held in trust for them so that someone else is managing the money with clear guidelines on how it's to be handled and how it's to be distributed. Important point. What happens if you don't do anything? Well, there's good news and the bad news, and it's all the same thing. The good news is that every single person in the audience of this presentation, and indeed every single human being in the state of California, has an estate plan. So right now, even if you have done absolutely nothing and have no intention to do anything, you have an estate plan. That plan is the law of intestate succession set forth in the California Probate Code. So the good news is that you have that plan. The bad news is that it probably isn't going to do what you want, and it's going to be very, very expensive. Law of intestate succession basically says that if a person dies, they don't have a will, they don't have a trust, they don't have any other means to dispose of their property, then that property will be distributed to the heirs, magic word, at law, as determined by California law. So if we're talking about a married couple where everything they have is community property, first death, not really a big deal. All community property goes to the surviving spouse. If there are children and there's separate property, then there's a division, again, all community property to the surviving spouse. Children get a portion of the separate property depending, and their portion depends on how many children there are, how it's split up. The problem with intestate succession is that it is inflexible. Number one, it's inflexible. So if you wish to make gifts, say, to charities, such as the Walnut Creek Library Foundation or whatever other charity warms your heart, the probate code doesn't provide for that. Also, it provides for some distributions that, frankly, most people probably wouldn't want. A good example, right now I'm handling a probate of a surviving spouse. So oddly enough, it was the husband. But, husband and wife, well, Mary and George for now, they were kind of typical people, and that atypical in California, they were married to the same people their entire lives after they were in their 20s. But, basically everything was community property except their house, which was held in joint tenancy. Their bank accounts were joint accounts. Their other accounts, they had designated beneficiaries, each other. Wife died, Martha died about 13 years ago. Very, very quick, no will, but it was very easy to take care of back then. There wasn't a whole lot. The house, joint tenancy, so all you do is file an affidavit of death of joint tenant. So it put the entire property in the name of the husband. Husband went to the bank and just said, "Hey, here's my wife's death certificate, give me the stuff." So it went very smoothly first death. Problem is the second death. He died without a will, and they had no children. He was very, very close to, both of them had been very, very close to his family, and they were estranged from her family. In the 13 years between her death and his death, he had absolutely no contact of any nature with her family. In fact, her family didn't even show up to her funeral. He died intestate. Everything goes through probate court. Now, on the disposition for the personal property, his bank accounts, things like that, they all go under to his mother, who oddly enough at 96 years old is still alive. So she would inherit all the personal property. The house, which is over 90%, probably 95% of the entire estate, though, is different, because under the law of intestate succession in California, since he had inherited half of that house from his wife less than 15 years after her death, that one half goes to her heirs, determined under California law, which in this case is her brother, who she really didn't have a relationship with, and the husband certainly didn't have a relationship with. Now, is that fair or right? I don't know. That's up to the legislature, not me. But the one thing I can guarantee you is that it is not what either she, the deceased wife, or the husband would want. And we've had a bunch of other cases where people die intestate and property goes to places that, again, whether it's a good idea or not, that's up to the legislature, but definitely not what the people involved would have wanted. So that's not a good thing. The other thing that's not great about intestate succession is that if you're talking about an estate that involves essentially any real property in excess of $50,000, which is anything in California except maybe some abandoned lot in the middle of the Mojave, or personal property in excess of this year, it's $184,000, requires going to the probate courts. We'll talk about that a little bit more in a second when we talk about wills. But it's a time-consuming, expensive process, which really benefits lawyers more than the people involved. The other thing about intestate succession is that even if it gives the property where you want, it may not be in the most effective way. The classic example is children. If your children inherit from you, minor children, they receive it outright and have complete control over it if they're 18 years of age. So my experience is that giving a large inheritance, or even a moderate inheritance, to a 16-year-old, particularly a 16-year-old boy, is not a great idea unless your plan really is that you want to benefit the local car dealers, because typically what will happen is the boy will inherit a lot of money, boy will buy a new car, boy will crash the car, boy will get a new car, and on we go. So those are some problems with intestate succession. So how do we deal with it? Well, the first thing that comes up is a will. And the first device is the will. What is a will? A will is basically just a document that becomes effective when you die that says where you want your property to go, who you want to administer it, and the terms. Okay, so the will and it can be a very elaborate document. I'm dealing with one right now, Chancellor, where it was put together. It's just like 150 pages of the most convoluted nonsense that I've seen in quite a while. Kind of a pain. Or it can be very, very simple. One of the first probate cases I had a long time ago was there was this delightful lady anyone who knew her told to was delightful. I never met her, but this nice lady named Leona Clay lived in Alameda County in Oakland. And one night she sat down on her bed or near it. She got out a piece of paper, and at the top she wrote the date, and then she wrote, and this is true, now I lay me down to sleep. I pray the Lord my soul to keep. If I should die before I wake, I want my Winchester rifle to go to my brother Dick. I want my house to go to all of my brothers and sisters in equal shares. And then she went on for about 2 pages disposing of a bunch of other stuff. And then at the bottom, she signed her name and she put it on her bedstead. And the next day she didn't show up to a breakfast that she was supposed to have with a friend. The friend went over to her house, found her deceased. That was her will. And it was valid. It was admitted to probate, called a holographic will, because it was entirely in her handwriting. It was dated, and it was subscribed, which means written at the bottom. If she'd written stuff below her signature, would have been disregarded. So it can be very, very simple. The key points of a will are, number one, you name who's going to receive your property, how they're going to receive it. You can appoint the person to manage it, the executor, it's called. And most importantly, for a lot of people, is that you can expressly state who you want to be the guardian for your minor children if you have them. And that can be very important, because I don't get involved in these type of contests anymore. Send it to a friend who has a much higher tolerance for frustration than I do. But some of the nastiest probates that I've ever heard of are contests between typically competing parents or siblings, grandparents or siblings, over who is going to be the custodian and the guardian for minor children. That just should be really nasty. So the will, what does the will do? It controls all property that doesn't pass other ways. So for example, things that you don't need a will to pass. Joint accounts. Joint accounts pass to the surviving joint owners. Real estate held in joint tenancy, again, passes without going through the will. Property that's held under what's called community property with right of survivorship passes under the terms of that. Transfer and death. The big items for most people are retirement plans, IRAs. They typically will have designated beneficiaries. And a key takeaway from tonight it could be is, if you have an IRA or a retirement plan, review your designated beneficiary to, number one, make sure it's appropriate who you want, but also make sure you have a designated beneficiary. Because if you, which is basically, you just in the plan says, if I die, give the stuff to my wife or my kids or whatever. If you do not have a designated beneficiary, then the plan goes to your estate, which would then be controlled by your will, but it would also have to go through probate. And one of the problems with a will is that anything that's passing through a will has to go through the probate court. That brings up another thing. Everyone, the people, when they figured out they don't have an estate tax problem, they want to avoid probate, which is a good thing to avoid. Why? Because it takes a lot of time. The minimum time for probate is about 9 months. And typically they're taking a year and a half, 2 years, or even more, just because the courts are so backed up. You file a petition for probate, you file the will, you file a petition to have the will admitted to probate, and the court may not hear that for 2 to 3 months. Then there's a whole series of processes that you have to go through, which take additional time, and it's kind of laborious. Another reason a lot of people don't like probate is that it's a public process. Your will is filed, if you have one. An inventory is conducted of everything that you own, which becomes a public record. Everything is done through probate. It's a pain. The only good thing about probate, and it's good for, not for you, but for lawyers, is that probate fees are determined by the probate code, and it's a cut of the action. And typically, the probate fees will be significantly more than the fees that would be required for handling a similar side estate through a trust or other devices, which we can spend time on, get into trust. So probate's generally good. How do we avoid it? Again, as I said, if you have property in joint tenancy, things like that, joint accounts, they pass without probate. Works real well often for a married couple at the first death, disastrous at the second death for the reasons that we just discussed. So the most commonly used and most effectively used device, particularly in California, although it's really sort of national, is a revocable living trust. You can call it sometimes called living trust, or just a revocable trust. What the heck is that? A trust is a document that basically it's set up while you're alive. It's a contract between you as the owner of property and you as the trustee or managing the property. And it provides for the administration of the property by a person named as a trustee for the benefit of a person named the beneficiary. The beneficiary, typically it's you, you're the person who's entitled to the benefit of the assets, the beneficial owner. The trustee is a person named to hold and administer those assets and has legal title to the assets. So they're used generally as a device for probate avoidance at death, but they're really, really handy to avoid conservatorships if you become incapacitated during your lifetime. So typically, the clients will put together a revocable trust. They will be, while they're alive, they will be the trustees. A typical trust would say that, between a married couple would say that if one of them dies, typically the other one is trustee, but you can name anyone you want. And then when neither of them are able or willing to act as trustee, then you designate the person, which can be a child, a friend, a bank, trust company, to manage it. The advantages of that is, number one, it avoids the probate, both at your death, but also if you become incapacitated, it avoids the necessity of appointing a guardian of your estate, which is what happens if you don't have a trust or anything. That's a procedure where someone files a petition with the probate court saying that you, for whatever reason, are unable to manage your affairs. The court will have someone investigate you, determine if that's true. If so, they appoint someone to manage the affairs for you under judicial supervision. Very complicated, time-consuming, and expensive procedure. But other than that, it's great. You can avoid that with a trust. So who doesn't need a trust? Well, people, if you don't have any real property, because real property, again, unless it's of minuscule value, if you don't have a trust, is going to be subject to probate. If it's owned by you jointly, it won't be subject to probate at the first death, but at the second death, then it definitely will. People who else doesn't need it? People who love their lawyers more than their family are ideal candidates for not having a trust. So we've talked about all that stuff. Let's talk about, we don't have a huge amount of time left. I want to talk about two things that are really, really important and are often overlooked. I mentioned them earlier, the durable power of attorney and the Advanced Healthcare Directive. A durable power of attorney is a document that appoints someone else to act for you with respect to your property while you're alive. Okay. A durable power of attorney is just a power of attorney that remains in effect if you become incapacitated. So, why would you want one of those? if you become incapacitated, if you don't have anything else in place, then we get into the conservatorship that I mentioned a moment ago, which can be a very difficult and expensive process. The other thing is that it's not uncommon, particularly with people who have significant wealth, to have competing children saying, no, mom and dad wanted me to take care of this and put me in charge, in which case they would have to fight it out before the probate court. Again, a time-consuming, expensive, and very destructive in terms of personal relationship situation. So with a durable power of attorney, you can grant broad powers and narrow powers, whatever you want, for someone else to manage things. Now, if the property is held in a trust, then all the assets that are in the trust are held and managed by the trustee without the necessity of any court proceedings or even durable power of attorney. So why do we want a durable power of attorney if everything's in the trust? Typically because there will be assets that aren't in the trust that the holder of the power of attorney can transfer to the trust. Also, the power of attorney holder can do other handy things, such as file your income tax returns, make burial arrangements, and things like that. So they're a good thing to do. It has to be durable. Again, because if you're incapacitated, if it doesn't say it's a durable power of attorney, if you're incapacitated, a non-durable power of attorney is worthless because it just puts the holder of that power of attorney, the agent, in your shoes. And if your shoes were such that you couldn't do anything, well, you can't do anything either. The other thing that I want to hit on is the Advanced Healthcare Directive. And that's really, really important. If you have the bad fortune of having to be admitted to a hospital for any reason, they're going to ask you if you have an Advanced Healthcare Directive. And if you do not have one, they will strongly encourage you to do one, which is a good thing. What does it do? First thing it does is that you can appoint someone to make healthcare decisions for you if you are unable to make them for yourself. You also can provide in there whether and under what circumstances you wish your life to be prolonged through so-called heroic means, if you are terminally ill or permanently comatose, or you can say, I don't want that. Other things that are often addressed by my clients is they may, have clients who want to be buried or want to be cremated or want their remains to be disposed of in a particular way. They can cover that. They can also deal with the question of whether they want to be organ donors. You can say no transplants, or you can say I will be an organ donor. You can, if you want to donate organs, you can limit the purposes for that. So it's just a handy thing to have. Now I see that we're running out of time according to the schedule that Kathleen gave me. So I think I'm going to open it up to questions. So there you go.
Thank you, Gordon. We do have quite a few questions.
Okay, good, because questions are the most fun. I always want to play Stump the Lawyer.
Okay, first question. Will my California will cover property I own in other states?
Yes. Assuming you die in California, California will have jurisdiction over your estate. Now, all of your personal property is considered to be where you are located. And that's under the law of every single state in the United States. The issue comes up is real property. So if you're a Californian, but you have property in Texas, then it will be governed by your California will. However, if it's a will that's involved, you will have to do a probate in Texas of just the property in Texas or any other state. If it's a trust, you don't have to do that. So this is another area where a trust is really, really handy for avoiding probate. Because if you're a California resident, you have property in whatever state you want, it will be governed by your California trust document. And since it's in the hands of the trustee, it will avoid probate in any other state.
Good answer. Thank you. What do you think about using NOLO, N-O-L-O, software to make a trust, if it is quite simple and without any complications?
One without complications. I have I've administered trusts that were done by NOLO on really, really simple situations, particularly everything to the children in equal shares. The children are all adults. You're not having any issues about holding trust for young people or incapacitated people or things like that. And they work pretty well. On the other hand, I've had some really, really profitable contested matters where people use, NOLO, or in some cases lawyers who didn't know what the hell they were doing, and have put together things which had ambiguities or lack of certainties that created conflicts. So, it really depends on the circumstances. But if it's a really, really, really simple and everyone's great, it can work real well. But if there's any complexity involved, or particularly if you're in a situation where there is a potential for conflict among the beneficiaries, not a good way to go.
Next question. Sally would like to know, should my bank checking account be part of my family trust?
Yes. Simple answer, yes. The advantage of that, okay, I see people hold these bank accounts in three ways. Okay, option one, it's just in your name. The advantage of that is you're the only one who has control over it while you're alive. That's also the disadvantage. So if you're incapacitated, then someone's going to have to take control over it. If you're dead, someone's going to take over it. If you're dead, it's a lot easier than if you're just incapacitated, because if all the property that isn't in your trust is less than, I think this year it's 184,000 and change, then you can pass that under what's called a small estate affidavit. You just have to wait 40 days until a person's dead before you can do that. Second way, a lot of people will do things is to have a joint account. So to be me and my favorite daughter, who I trust to take care of everything. That works fine in a lot of cases. While you're alive, it's very nice and convenient. Problem is, if you die, then under the law of this state, everything in that account goes to the co-owner. Doesn't get split among all the kids equally. It's not part of the trust. So, and that may or may not be what you want. The advantage of having the trust is that if anything happens to you, it's a very simple procedure for the successor trustee, who's named in the document, to go to the bank. If you're dead, you have a death certificate. A statement basically says, Sally was a trustee of the trust. The trust owned this account. Sally's no longer with us. I'm the successor trustee. Give me the money. Very, very simple procedure. You don't have to wait 40 days, and it just works really well.
Next question. Can someone include assets that are not located in the U.S. in a will or a trust?
Yes. The answer is yes. There are complications. So, for example, I've clients right now who have property that are included in their wills or in a trust that are in the UK, Israel, which has some interesting laws and some other stuff. So you have to even though you can put it in your California will or trust, you still really need to coordinate with someone who knows the law, particularly of the other jurisdiction. So, for example, we have a client who has a lot of property in the UK. So we worked with a UK lawyer to make sure that that property was properly held in the trust, deeded in the trust. And every country is a little bit different. So the answer is yes, but it's a little more, you still have to deal with the law of the other country because it will govern the disposition administration of property within its jurisdiction.
Next question. How often should a trust be updated and how do you go about that?
It's a really good question. And it comes down to circumstance. I generally like to have my clients, to pull it out, look it over every, say, 3 years, 3 to 5 years. And whenever there's a change of circumstances. So, for example, my wife and I right now are redoing our estate plan because we now have 2 grandchildren. One's 5 months old, one 9 months old. And we're going to be making some revisions so that some gifts that would have gone to our daughters instead are going to go into educational trust for grandchildren. If there's a change in law, that's always a good thing to do. So but in terms of just a general review, you should look at it probably every 3 to 5 years. And then if there's change of circumstances, sort of thing. And it's good to have it reviewed by the lawyer who drafted it or someone else, probably, I'd say every 5 years. One thing that is coming up in 2026 that will cause a lot of people to look at their stuff if they're wealthy is that the current very generous estate tax credit is going to be cut in half in 2026. Now they're not going to eliminate portability, but that means that instead of being able to pass roughly, $12.5 to $13 million without paying tax, you're only going to be able to pass, $6 or $7 million without paying tax. Still not an issue for most people, but California real estate continues to inflate at a high rate. Maybe something more people need to look at.
Great. Next question. Generally, what would be the cost for an estate plan from your office for a large and or small estate? Is it an hourly fee or a flat fee for preparing an estate plan?
Again, it depends on the circumstances. And so for a small estate, let's say typical estate, moderate and married couple, we don't have special needs issues. We don't have estate tax issues. We don't have generational issues. It's really, it's not one size fit all, but it's kind of typically what most people are going to want. Depending upon the number of real properties they have, it's gonna range between $3,600 and $4,200, and we can do that on an hourly or a flat. Generally, what I'll do is we'll meet with the client in a first meeting, which is no fee, and when what we're looking at, you can generally give them a flat fee or an option of either way. Large estates, really, it's almost impossible to quote those, depending on the situation. So if we're looking at substantial estate tax exposure, then there's a number of things that can be done to avoid that, whether it's charitable planning, SLAT, the spousal lifetime access trust, a lot of different types of trusts. Those are generally done on an hourly rate, just because it's really designed specifically for the specific situation. They require a lot of analysis, and those can be quite expensive. I mean, a typical irrevocable trust is going to be, even if the going to be probably $7,500 plus. But the one thing I can guarantee, whether it's done by my office or someone else, is in those situations, whatever you pay is going to be a lot less than what you would have paid in estate taxes if you hadn't done it.
Follow-up question. What is a large estate versus a small estate?
That is a moving target. Right now, and unless they change the law, if you're looking at just avoidance of estate tax for a married couple, you don't have to worry about that until in excess of $24,120,000, which in 2026 will go down to half of that, so around $12 million. That's not good. So generally, most people think of a moderate estate as being about 3 million plus. Small estate, 3.5 million or less. Really, again, unless you're looking at complicated estate tax issues, what drives the complexity of the stuff really is a personal situation. So if you have a moderate estate, let's say $3 million to $10 million, even if you don't have estate tax issues, there will be other issues. So, for example, if you're conveying stuff to children, well, you may not want your children to be controlling that much wealth at age 18. So with a trust, you can decide when you want them to get control. Most people will look at it somewhere between giving control between 25 and 30 years of age. We'll have clients who've put things in trust for 45, 50, and even more. The key is, and I want to be upfront, is because I'm beginning to slow down and limit my practice. So I'm taking less clients, and there are I'd love to do business, but there are a lot of really good estate planners, particularly in Contra Costa County. So if you're looking for someone, and a situation where for whatever reason I'm not able to handle it, one thing I'd suggest people do is you go to the State Bar of California, and you can look up lawyers. You want to make sure that they know what they're doing. And the best way to do that is to make sure that they are certified by the State Bar of California as a certified specialist in the area of estate planning, probate, trust administration. There are a number of people that I refer stuff to. I don't do conservatorship work. I typically send that to either Kirsten Howe or Demir's firm. If you're dealing with special needs trust, that's a super complicated area that I used to be active in, but found that I just didn't want to follow it. So I send that out. I don't know, it's probably what you want to hear, but that's it. So again, I think that, unless you're looking at estate taxes, what drives it is the complexity of what you want to do.
Thanks. Just two more questions.
Okay.
You mentioned a trust can designate more than one generation. Is there a maximum number of generations that can be outlined in a trust?
No, but sort of. So you can have a trust that, goes on infinitely forever. California, most states have a law called the Rule Against Perpetuities, which basically says that any interest in a trust has to vest. come into play within a fixed period of time. And under California law, that is the later of 90 years from when it's created, the document's created, or 21 years after the death of a person designated in the document who is living at the time of the document. So we'll have documents which basically theoretically could go on forever, multi-generational, providing for children, grandchildren, but the rule against perpetuities is going to come and cut it off at some point. Now, there are several states, Dakotas and Alaska, that have eliminated the rule against perpetuity. So in those states, you could set up a trust, if I've ever done one, that would basically say, hey, everything stays in trust and you can use it for the benefit of the generations downstream, theoretically forever. But in California, basically 90 years or 21 years after someone who is when it's created. Now, the typical California trust will say that it'll be, all trusts, will be terminated 21 years after the death of, my descendants who are alive at the time of my death, something like that.
Last question.
Okay.
Is it better to give while you are alive or at your death?
Depends. If you have an asset that has appreciated in value during your lifetime, then generally speaking, it's better to have that pass at death. The reason is that under Section 1014 of the Internal Revenue Code, any assets that are owned by a person at the date of their death receive an income tax basis adjustment to the fair market value as of the date of the death. So, for example, if you have a bunch of Apple stock, although probably not as good an example today as it was last November, you have a bunch of Apple stock that you bought for $1 a share, and when you die, it is valued at $170 a share. It gets a basis adjustment to $170 a share. So if the person who received that sells it immediately, no income tax on that gain. Same situation if you gave it during your lifetime, there's not a basis adjustment. So whoever you give it to gets it with the same income tax basis that you had, and therefore if they sell it, they're going to pay a whole lot of capital gains tax. Now, on the other hand, if we're talking about personal items, things that aren't appreciated, there's a lot to be said for giving stuff while people are alive. They can still use it, and you can enjoy watching them use it.
Okay. Well, thank you, Gordon, and thank you all for joining us today. All of you who have registered for this event will receive a link to the recorded video and presentation that will be placed on YouTube. If you've enjoyed tonight's program and look forward to more, we invite you to make a gift to the Library Foundation on their website. Your gift makes a difference. We hope you'll return next Thursday for the library program, Finance 101, Special Needs Planning, Much More Than Government Benefits, with Kirsten Howe, founder and managing director of Absolute Trust Council. More information and the registration link can be found on the Walnut Creek Library Foundation website. Thank you again for attending, and good night.